You won't get anything, not even $1. That's what my sister told me calmly, like she was confirming the weather. Then she added that I shouldn't bother showing up to the inheritance meeting. My presence, she said, would only slow things down. I remember standing there 31 years old, nodding as if I agreed, because arguing wouldn't have changed a thing. In that moment, it felt like I had already been written out of the story. But 5 minutes after that meeting began without me. Everything shifted. After my father, Daniel passed away, the balance inside our family didn't collapse all at once. It tilted, quietly, almost politely. For months, even while he was sick, he kept the store under his direct control. Not because he didn't trust us, but because he believed responsibility had weight. He reviewed inventory himself, approved payments personally, kept financial records close as if the numbers were a part of his pulse. The store wasn't just a business to him, it was a living extension of our family. While he was alive, nothing about it belonged to one person. Decisions were discussed, sometimes postponed, sometimes left unresolved because he preferred caution over speed. No single child stood in line as the obvious successor. That delicate balance, fragile, imperfect, held us together longer than I realized at the time. But after the funeral, that restraint disappeared almost immediately. Marissa came back with urgency. Not loud grief, not visible hesitation, urgency. Within days, she was at the store every morning, talking to suppliers, reviewing staff schedules, answering calls that used to be directed to Dad. None of it was formally announced. There was no family meeting where roles were assigned. It happened through repetition, through presence, through assumption, and I watched it unfold. At first, I told myself it was temporary. We had just buried our father. Someone needed to keep things moving. But routine decisions slowly stopped passing through me. Financial questions that once would have been shared were redirected. When I asked about invoices or upcoming payments, the answers came filtered summaries instead of details. Access narrowed. Subtly, logins were changed for security. Documents were still being organized. Conversations that used to happen at the kitchen table now happened behind closed doors at the store. I wasn't told I was excluded. I was simply no longer included. When I asked for updates, the responses were calm, almost rehearsed. This is temporary. We just need stability right now. It's a difficult time. Nothing was framed as permanent. And yet the pattern was consistent enough to feel intentional. Mom supported Marissa openly. She said the store needed one clear voice after everything we had lost. She talked about efficiency, about continuity, about how too many opinions could create confusion. In her view, leadership mattered more than fairness. Hesitation was a risk. I remember sitting at the table while she explained that grief wasn't an excuse for disorder, that emotions had no place in business decisions. It wasn't harsh, it was practical. That was what made it harder to argue with. But something shifted in the language around the store during those weeks. It stopped being our family store. It became the business, then the operation, and eventually just the asset. The change was subtle, but I heard it every time. An asset is something you manage, something you position, something you can move when the timing feels right. A family store is something you protect, something that carries memory. The more Marissa positioned herself as the point of contact, the more the store started to feel like leverage. Suppliers called her first. Employees waited for her approval. Even external partners began assuming she spoke with final authority. Access creates perception, and perception over time becomes power. I noticed it, most in the small moments. A delivery schedule adjusted without my input. A financial report summarized instead of shared in full. A decision already implemented by the time I heard about it. When I questioned the shift, the answers came quickly and cleanly. We can't afford delays. It's better if one person handles this. We need to protect the value of the business. Protect the value. Not preserve the legacy. Not honor Dad's structure. Protect the value. And I started to understand that this wasn't just about keeping the store stable. It was about defining who had the authority to shape what came next. The hardest part wasn't that Marissa stepped forward. It was that she stepped forward without ever acknowledging that the ground belonged to both of us. There was no conversation about shared responsibility, no agreement about temporary leadership, just a steady consolidation of access. Mom reinforced that approach every time I hesitated. She said fewer voices meant fewer conflicts, that after losing Dad, the last thing we needed was internal friction. In her mind, unity meant alignment. Alignment meant efficiency, and efficiency required someone to lead. What unsettled me most was how quickly disagreement was reframed as disruption. If I asked too many questions, I was complicating things. If I requested documents, I was slowing progress. If I suggested waiting before making major decisions, I was being emotional. I wasn't shouting. I wasn't resisting publicly. I was observing. And the more I observed, the clearer it became that the store had stopped being something we shared and started being something that established hierarchy. Dad had always separated ownership from control in practice. Even when he held both, he treated them carefully. He believed authority should be deliberate, not assumed. After he was gone, assumption replaced deliberation. By the time weeks had passed, the shift no longer felt temporary. It felt structured. The balance that once required patience and discussion had been replaced by speed and consolidation. And the store, once a symbol of continuity, now stood at the center of a quiet power struggle I had never agreed to enter. I didn't challenge it head on, not yet, but I stopped pretending I didn't see it. A few weeks after the funeral, the conversation shifted again. It was no longer just about who was managing the store day to day. It became about whether we should keep it at all. Marissa didn't present the idea gently. She didn't ask how I felt about it or whether I thought we were ready to make that kind of decision. She spoke about selling the store as if the process were already in motion, as if the conclusion had been reached somewhere I hadn't been invited to sit. She called it the most financially responsible option, said that holding on no longer made sense given the circumstances. Waiting, in her words, would only reduce its value. The way she spoke wasn't emotional, it was strategic, focused on timing, on market conditions, on being smart rather than sentimental. But what caught my attention wasn't the suggestion itself. It was how far along it already sounded. Brokers had been contacted. Documents were mentioned casually like background noise. Numbers were referenced. Valuations, projections, but without context. I wasn't shown the assessments. I wasn't asked whether I agreed with the price range. I wasn't included in any of the preliminary conversations that supposedly led to this conclusion. It felt less like a proposal and more like a briefing. When I asked how the store had been evaluated, whether multiple offers had been considered, whether we'd compared long-term income to a one-time sale, Marissa dismissed the questions with a calm firmness that left little room to push. "The details are being handled," she said. "There's no need to complicate things with too many opinions." Too many opinions. I remember that phrase clearly. It lingered longer than it should have. I asked why the decision felt so rushed. The store wasn't failing. There hadn't been any urgent financial strain that I knew of. Dad had kept it stable for decades, even through downturns. So, why the urgency now? Marissa shifted the focus away from the business itself. She said prolonged discussions would only create delays, that unnecessary tension would damage the process. In her view, moving quickly wasn't about control. It was about responsibility. Responsibility, efficiency, timing. The words were polished, almost rehearsed. But underneath them was something quieter, an assumption that my hesitation was irrational, that my questions were obstacles rather than contributions. I wasn't treated as someone with equal stake in the outcome. I was treated as someone who might slow it down. And then the inheritance meeting entered the conversation. She described it as procedural, just a formal step, something that needed to happen so everything could move forward smoothly. According to her, there was nothing for me to contribute. "There's really no reason for you to attend," she said. "It'll just complicate things." I asked her directly why I was being excluded from a meeting that involved assets we both had a stake in. Her answer avoided the core of the question. She said it wasn't about exclusion, it was about practicality. Fewer voices, smoother process. That was the logic. But I noticed what she didn't say. She didn't mention agreement. She didn't acknowledge that consent mattered. She didn't frame it as a conversation we should both be part of. It was already framed as something being managed. Mom supported her without hesitation. She said the family had already been through enough, that we didn't need more friction, that the meeting wasn't a place for emotions or unresolved disagreements. My presence, she implied, would introduce both. I remember sitting there, listening to them describe my attendance as a potential disruption. Not a right, not a responsibility, a disruption. The tone wasn't hostile. That's what made it harder to confront. It was calm, measured, almost concerned. They spoke as if they were protecting me from unnecessary stress, when in reality they were protecting the process from my input. The boundaries were drawn clearly without ever being declared. The store was no longer something we shared. It was becoming a transaction to be finalized. Documents were already in motion. Conversations had happened without me. And now the formal meeting, the one that would solidify everything, was being presented as something better handled in my absence. I didn't raise my voice. I didn't argue in circles. I simply asked again why a decision of that magnitude required me to stay away. Marissa's expression didn't change. "It's already being managed," she said. "Trust the process. Trust the process." It's interesting how easily that phrase can replace transparency. By the end of the conversation, nothing had been resolved. Not because there was nothing left to say, but because it was clear that the direction had already been chosen. The meeting would go forward. The sale discussions would continue, and I would not be in the room. I felt something shift in that moment. Not anger exactly. Not even betrayal in its loudest form. It was subtler than that. A realization that I was no longer being treated as equal, but as excess. As someone whose presence needed to be managed rather than welcomed. The store had become leverage. Authority had become centralized. And my role had quietly moved from participant to observer. When she finally told me without hesitation, "You won't get anything, not even $1, it didn't sound like a threat. It sounded like a conclusion she believed had already been secured. And when she advised me not to attend the meeting, it wasn't framed as a request. It was an instruction. The conversation ended, not with shouting, but with certainty. Their certainty. I didn't argue further. But I also didn't accept the narrative as final. After that conversation, I stopped trying to convince my sister of anything. Every answer she gave me felt filtered, shaped to move things forward quickly, not necessarily truthfully. Questions about documents were softened, timelines blurred, responsibility dressed up as urgency. I realized I wasn't going to find clarity by pushing harder in the same direction, so I stopped arguing. Instead of pressing Marissa for explanations she clearly didn't intend to give, I decided to verify what I could on my own. Not out of suspicion at first, more out of instinct. If something felt incomplete, maybe it was. The first person who came to mind was Linda. Linda had been my father's assistant for over a decade. She wasn't just someone who handled scheduling or paperwork. She had been present for everything: vendor negotiations, financial reviews, legal consultations. If there was anyone who understood how my father structured his affairs, it was her. She had stayed quiet after the funeral, respectful, distant. I think everyone assumed she would fade out once the formalities were done. When I called her, she didn't sound surprised. She didn't ask why I was reaching out. She didn't ask what had happened. She simply said I wondered how long it would take. That sentence alone shifted something in me. We met in person a few days later. There was no drama in the way she spoke, no accusations, just measured clarity. The first thing she confirmed was that my father had not left anything vague or informal behind. Despite what Marissa implied, despite the sense that everything was still being figured out, my father had been deliberate. He had prepared his will carefully, revised it more than once as his health declined. Not impulsively, not emotionally, thoughtfully. Linda explained that during those final months, he worked closely with his attorney. They didn't just discuss who would receive what. They discussed structure, safeguards, conditions tied to management decisions involving the store. That word conditions caught my attention. My father, she said, had been very clear about separating ownership from control. He understood that confusion between the two often creates conflict. Just because someone owns part of something doesn't mean they automatically control it. And just because someone manages something doesn't mean they have the right to make irreversible decisions alone. According to Linda, those distinctions weren't abstract ideas. They were written into formal provisions, documented, signed while he was fully competent, reviewed carefully. There was nothing rushed about it. Listening to her, I felt something I hadn't felt in weeks: steadiness. Up until that point, everything around me had felt like shifting ground. Decisions moving ahead, language evolving, my presence being reframed as optional. But what Linda described wasn't shifting at all. It was fixed, structured long before any of this began. Before our meeting ended, she reached into her bag and pulled out a sealed envelope. I recognized the handwriting immediately. It was my father's, careful, deliberate script across the front. My name written the way he always wrote it, slightly slanted at the end. Linda told me he had instructed her to give it to me only if certain circumstances arose. She didn't elaborate. She didn't need to. By then, I understood. He had anticipated tension. He hadn't been naive about what might happen once he was gone. He hadn't assumed that good intentions would automatically hold everything together. I didn't open the letter right away. Holding it was enough. It wasn't thick. It wasn't dramatic. Just a few pages sealed, but the weight of it felt different from everything else I had been handed in those weeks. This wasn't filtered through someone else's interpretation. This was direct. When I finally read it later, it wasn't emotional in the way I might have expected. He didn't accuse anyone. He didn't predict betrayal. He didn't warn me to be careful. He explained his reasoning calmly. He acknowledged that disagreements might surface, that silence might be mistaken for weakness, that structure was not a lack of trust, but a way to protect everyone involved. One line stayed with me not because it was dramatic, but because it was simple. He wrote that preparation is not pessimism, it is responsibility. There was no instruction to fight, no instruction to confront, just clarity about what he had put in place and why. Reading it, something shifted inside me. The confusion that had been building, the sense that maybe I was overreacting, maybe I was misreading things, started to dissolve. If my father had revised his will carefully, if he had separated ownership from control intentionally, then what was happening now wasn't a gray area. It was a miscalculation. Someone had assumed that access equaled authority, that speed equaled legitimacy, that confidence equaled control. But structure doesn't disappear just because someone moves quickly. For the first time since the funeral, I felt no urgency to defend myself. No need to correct assumptions in real time. What had been framed as a decisive process suddenly looked procedural, surface level. If the will was as deliberate as Linda described, if the provisions were as clear as my father intended, then legitimacy didn't depend on who showed up first. It depended on what had already been written. And that realization changed how I viewed the meeting everyone was so eager to finalize. It wasn't the center of authority. It was simply a step. Silence, I began to understand, did not mean exclusion. It meant I was no longer reacting. I was waiting. That Sunday, the meeting went forward exactly the way my sister wanted it to. I wasn't there. The conference room had been prepared early that morning according to the records I later reviewed. Folders laid out neatly, copies of the estate file stacked in order. It was meant to feel official, controlled, predictable. Mr. Collins, the attorney responsible for formally reading my father's will, arrived first. He carried a complete copy of the estate documents, everything filed, signed, and notarized. Shortly after Mr. Hargrove joined him, he had worked with my father on prior legal matters and was familiar with the structure of our family's business. Between the two of them, there was no ambiguity about procedure. Everyone present assumed my absence was procedural rather than intentional. The notice had stated that all beneficiaries were welcome to attend. No one raised concerns when one chair remained empty. From the outside, it likely looked like a simple scheduling decision. When the meeting began, the tone was steady, professional. Marissa listened closely as the primary provisions were read aloud. These sections covered general asset distribution, outstanding obligations, administrative details, standard language that would have sounded reassuring to anyone expecting control to pass smoothly. Nothing in the opening portion challenged her expectations. From her perspective, Everything was unfolding exactly as planned. The confidence she had shown in the weeks leading up to this moment probably felt justified. She'd been managing the store, communicating with suppliers, referencing brokers, acting as though authority had already consolidated around her. And for the first part of that meeting, nothing contradicted that belief. Then Mr. Collins paused. Not dramatically, not theatrically. Just a measured pause before continuing. He referenced an additional clause attached to the main document filed separately, but carrying equal legal weight. It wasn't an afterthought, it was an intentional addendum. The room, I was told, shifted slightly at that moment. Not tense yet, just attentive. Mr. Collins began reading. The clause addressed participation and interference during the transition of estate assets. It stated clearly that if any named heir was deliberately discouraged, misled, or excluded from attending the formal reading of the will or subsequent decision-making sessions, authority over contested assets would be automatically reassigned. Automatically. There was no requirement for proof of malicious intent. No need to demonstrate emotional harm. The language focused on actions, specifically whether an heir had been obstructed from participating in a required legal process. It did not accuse anyone. It did not name anyone. It simply created a safeguard. If exclusion occurred, the authority to manage the asset in question would be redirected away from the party responsible for that interference. The attorneys did not rush past this section. They clarified it. Under the terms my father had drafted, participation in the inheritance meeting was not symbolic. It was a legal right, tied directly to management authority. Discouraging attendance, if documented, met the threshold of interference. At that point, Mr. Hargrove reviewed the communications that had been submitted prior to the meeting. Those records included written instructions advising me not to attend, messages framing my presence as unnecessary, language suggesting the process would be smoother without me. The tone of those messages mattered less than their content. I had been told not to show up, not casually, not ambiguously, directly. Under the clause's language, that behavior qualified as intentional obstruction. The will did not require that I be physically barred from the room. It required only that I be deliberately discouraged from exercising my right to attend. And that had happened. Once that determination was made, the consequence followed exactly as written. Control over decisions related to the family store was immediately removed from Marissa's authority. There was no vote, no negotiation, no interpretation session. The clause had been triggered. My father had specified that in cases of interference, management rights over contested assets would be reassigned according to predetermined conditions. The purpose was explicit to prevent any heir from manipulating access in order to secure leverage before final settlement. The store, the very asset that had become the center of urgency and consolidation, was now legally stripped from the control of the person who had attempted to streamline its transition. The meeting, which had been designed to finalize authority, could not proceed as originally intended. Questions were raised. Objections were attempted. But the language of the will left no flexibility. It had been drafted precisely for this kind of scenario where confidence might replace fairness and speed might override consent. The attorneys explained that the clause was preventative, not punitive. It existed to preserve structural integrity during the most volatile stage of inheritance, the transfer of control. And it had functioned exactly as designed. What stands out to me isn't that my father anticipated disagreement. It's that he anticipated overconfidence. He understood that authority claimed too quickly can destabilize everything. Within 5 minutes of that clause being enforced, my phone rang. The caller ID displayed Mr. Hargrove's name. His voice, when I answered, was controlled but urgent. Not panicked, not emotional, just precise. "Can you come to the office immediately?" he asked. There was no elaboration at first, just a request framed as time-sensitive. Before I could even process the shift, another notification appeared on my screen. A message from Marissa, shorter than anything she had sent in weeks. "Maybe we can negotiate." That was it. No explanation, no acknowledgement of what had changed. Just a sudden pivot from certainty to discussion. I didn't respond right away. From where I stood, the outcome had already shifted. The meeting that had been described as procedural something I didn't need to attend had activated the very safeguard my father had put in place to protect against exclusion. Without stepping into that room, without raising my voice, without confronting anyone publicly, I had become central to the process. Not through emotion, through documentation. That Sunday ended without resolution. No signatures, no finalized sale, no confirmation of control. The authority over the store no longer rested in the hands of someone who believed exclusion was strategy. It had been redirected according to conditions established long before any of us thought we'd need them. 5 minutes. That's how long it took for certainty to unravel. And everything that followed began with that pause in the room when an additional clause quietly attached changed the direction of the entire story. The shift the next morning was immediate. Less than 24 hours earlier, my absence had been treated as irrelevant. Now suddenly my cooperation mattered. Marissa and Mom arrived at my door unannounced. They weren't angry at first. There were no raised voices, no accusations. Just a carefully controlled calm that felt practiced on the drive over. They said things had escalated too quickly, that misunderstandings had been blown out of proportion, that before anything became irreversible, we should talk privately. It was framed as concern, as an attempt to protect the family from unnecessary damage. Marissa chose her words carefully. She said the situation had become more complicated than expected. She suggested that resolving it outside of formal legal channels would be better for everyone involved. She talked about preserving family dignity, about avoiding legal expenses, about how court proceedings would only create wounds that couldn't be undone. On the surface, it sounded reasonable, but beneath the language of unity was something else, an assumption that we could simply reset the narrative without acknowledging what had triggered the clause in the first place. There was no mention of the messages advising me not to attend, no recognition that exclusion had been documented and reviewed. Family unity was suddenly urgent, but fairness had never been. I listened without interrupting, not because I agreed, but because I wanted to hear how far the tone had shifted. The same meeting that I was told not to attend was now being described as a misunderstanding. The same authority that had felt unquestioned was now described as flexible. When Marissa finally proposed a private arrangement, an informal understanding that would simplify everything, I answered clearly. Any discussion involving the store or the estate would go through legal counsel. I didn't negotiate terms. I didn't argue details. I just set the boundary. The air changed instantly. Marissa's composure cracked first. She accused me of escalating the conflict, said that bringing lawyers into it would destroy what little relationship we had left. Mom echoed that sentiment, insisting that family matters should stay within the family, that my refusal to engage privately proved I was being rigid. Neither of them acknowledged that I had been excluded from every decision leading up to that moment. Unity, it seemed, was important only when control had already shifted. When it became clear I wouldn't reconsider, they left abruptly. No resolution, no agreement. Just a quiet understanding that the informal path had closed. Within hours, the pressure shifted again. Marissa posted a public message on social media. She didn't name specifics, but the framing was clear. She portrayed herself as the responsible sibling burdened with managing the aftermath of our father's death. She implied that I was obstructive, emotional, resentful. It was subtle but deliberate. The narrative positioned her as practical and me as disruptive, despite the documented evidence that I had been advised not to participate in the first place. I didn't respond publicly. I didn't comment. I didn't correct the story online. I didn't defend myself in indirect ways. Instead, I forwarded every message, every post, every interaction to my attorney. Silence in that moment wasn't avoidance. It was alignment with the structure already in place. What stood out most was the contrast. Appeals to family unity were made only after documented exclusion had consequences. Private negotiation was offered only after authority had been reassigned. Concern arrived once certainty disappeared. By the end of that day, I understood something clearly. This wasn't about misunderstanding anymore. It was about control. And from that point forward, every step would move through formal channels. The escalation wasn't emotional. It was procedural. Months later, the conflict reached the courtroom. By then, whatever remained of family conversation had already been replaced with filings, affidavits, and scheduled appearances. The emotional tension that once filled our kitchen had been distilled into documents, dates, clauses, exact wording. The courtroom itself was quiet, almost restrained. There was no dramatic energy in the air, just procedure. I sat beside Mr. Collins, listening as he organized the final materials with a calm confidence that felt grounded in preparation rather than hope. Marissa entered with a different posture, not aggressive, not visibly shaken, but there was still a trace of the certainty she had carried from the beginning. The belief that early access and active management translated into rightful authority. When proceedings began, her attorney framed the dispute carefully. He described it as a misunderstanding between siblings during an already difficult time. He suggested my absence from the inheritance meeting had been voluntary, that any instructions regarding attendance were meant to reduce tension, not create exclusion. According to his argument, actions taken afterward regarding the store, the sale discussions, the consolidation of control were done in good faith to preserve the value of the business. It was a narrative built on interpretation. Not denial exactly, but reframing. The suggestion was that emotions had clouded perception, that what I viewed as exclusion was merely an attempt at efficiency, that the clause in my father's will had been triggered by miscommunication rather than intent. When Mr. Collins stood to respond, the tone shifted, not in volume, but in structure. He didn't begin with family history. He He didn't speak about fairness or hurt feelings. Instead, he outlined the architecture of the will itself. He emphasized that my father had revised it multiple times while fully competent, that independent counsel had reviewed its provisions, that clarity, not flexibility, had been the goal. Then he turned to the protective clause. The language, he explained, was direct. If a named heir was deliberately discouraged, misled, or obstructed from participating in a required legal process, including the reading of the will authority over contested assets, would be reassigned automatically. Not conditionally, not subjectively, automatically. The court was presented with the communications leading up to the meeting. Written instructions advising me not to attend, messages framing my presence as unnecessary, language suggesting the process would be smoother without me. There was no need to speculate about tone. The documentation was clear. Marissa's defense relied on intent on the idea that there was no malicious purpose behind the messages. But the clause did not hinge on malicious intent. It hinged on action. The judge focused on that distinction. What mattered was not why the instructions were sent, but whether they constituted deliberate discouragement from participating in a legally significant event. The evidence showed that they did. Mr. Collins also addressed an argument raised by the opposing side that the meeting would have proceeded the same way regardless of my attendance. But the will defined participation as a right tied to authority, not as a ceremonial presence. The structure my father designed assumed that access itself carried legal weight. Attempts to portray the clause as ambiguous were countered by documentation showing it had been reviewed independently before my father's passing. The judge acknowledged this directly, noting that the provisions wording left little room for interpretation. Clarity had been intentional. When the ruling was delivered, it was done without flourish. The court affirmed the full validity of the will, including the protective clause. It determined that the documented communications advising me not to attend met the threshold outlined in the provision. As a result, Marissa was formally stripped of any unilateral authority to sell, transfer, or manage the family store. Control over decisions related to the business was reassigned according to the conditions specified in the trust structure my father had established. The ruling also stated that any future attempt to bypass those conditions would constitute a direct violation of the estate order. It wasn't framed as punishment. It was framed as enforcement. What struck me most in that moment wasn't triumph. It was finality. The judge made it clear that the decision resolved not only the question of control, but the legal boundaries between us moving forward. Communication regarding the estate was to occur strictly through counsel. There would be no informal reinterpretation of roles, no room for private renegotiation outside the framework already established. As the hearing concluded, I felt something settle. Not satisfaction, not vindication, closure. For months, the conflict had revolved around speed versus structure, access versus authority, interpretation versus documentation. In the end, structure held. My father had anticipated tension. He had chosen precision over sentiment. And in that courtroom, precision proved stronger than assumption. The legal resolution did not repair family ties. It did not restore what had been lost after his passing, but it did something quieter and more permanent. It drew a line that could not be crossed again. When the ruling was handed down, nothing dramatic happened. No one gasped. No one stormed out. The judge's words were calm, almost routine, but their meaning carried weight that settled quietly into every corner of the room. Marissa lost control that day. Not symbolically, not temporarily, formally. The authority she had assumed spoken about with brokers, referenced in draft documents, exercised in conversations where Rosalind's name was deliberately absent, was removed in a single structured affirmation of the will's terms. The protective clause was upheld exactly as written. The trigger had been clear. The exclusion had been documented, and the consequence had been automatic. There was no ambiguity left to argue. The trust provisions, which had seemed abstract months earlier, now moved into active enforcement. Ownership and control, so carefully separated in the revised estate plan, operated as designed. The store would not be steered by whoever spoke the loudest or moved the fastest. It would be governed according to the structure their father had formalized. Marissa's authority was stripped not out of spite, but because the document required it. The court affirmed the will's clarity, her influence narrowed to what had been written. Informal alliances no longer carried weight. Verbal understandings dissolved against the documented plan. What remained was the structure their father had anticipated. The fracture in the family, though, did not heal simply because the legal question was resolved. If anything, the silence that followed felt heavier than the arguments that came before. There were no more urgent calls about brokers, no more forwarded listings, no more appeals to unity framed as necessity. There was distance, permanent or close to it. Rosalind did not celebrate. She did not issue statements. She did not counter the narrative that had once painted her as obstructive. She understood something now that she hadn't before. Public defense would not restore private trust. What she did instead was step into the role her father had quietly prepared her for. Not emotionally, structurally. The will had never intended for her to manage the store alone out of loyalty or sentiment. It had provided mechanisms, oversight standards, reporting requirements, professional safeguards. So she used them. Rather than consolidating power in herself, Rosalind appointed professional management. An experienced operations director was brought in under formal contract. Financial reporting moved to an independent accounting firm. Vendor relationships were reviewed and documented. Decision-making authority was clarified in writing, not assumed in conversation. It wasn't a dramatic overhaul. It was a restoration of structure. Employees who had sensed instability began to relax once processes became predictable again. Suppliers stopped asking quiet questions about ownership. The store returned to operating as it had for decades, steady, disciplined, intentional. And Rosalind learned something else in the quiet months that followed. Silence can be a boundary. It is not always punishment. It is not always avoidance. Sometimes it is a refusal to re-enter a cycle that has already proven itself damaging. Her mother attempted once to reopen personal conversation carefully, indirectly. Marissa sent a short message months later, neutral in tone, suggesting they move forward. Neither message was hostile. Neither addressed what had happened. Rosalind did not respond beyond what was legally required. The trust remained in place. The authority remained defined. The documentation remained unchanged. Family dinners no longer included discussions of expansion plans. Holidays became smaller, quieter. The easy familiarity they once shared did not return. Perhaps it could not. The fracture was not caused by the court ruling. It had been revealed by it. What endured was the clarity her father had built into his estate plan. He had anticipated pressure. He had anticipated disagreement. He had even anticipated exclusion. And he had responded, not with emotion, but with structure. Rosalind now understood that the inheritance was never just the store. It was the responsibility to protect it from instability, including instability within the family itself. She did not raise her voice to defend her position. She did not need to. The document spoke, the court affirmed, the structure held, and in that steadiness, quiet, deliberate, unyielding, Rosalind finally felt something she had not felt since the first hurried proposal to sell. Not vindication, not triumph, clarity. The store stood as it always had. The doors opened each morning. The ledgers balanced. The staff worked. Customers came and went, unaware of the legal clauses that had safeguarded the business behind the scenes. And Rosalind, no longer confused or sidelined, stood exactly where her father had placed her. Not as an inconvenience, not as an obstacle, but as the one entrusted to ensure the foundation remained intact. This story was never about revenge. It was about boundaries, preparation, and the quiet power of clarity. Inheritance doesn't only pass down assets, it carries expectations, assumptions, and sometimes pressure. What safeguards have you put in place? What conversations are still unspoken in your own family? If this reflection resonated with you, feel free to share your thoughts below and stay connected for more stories that explore legacy law and the choices that define us.